And we're recording. Welcome to Next Gen. My name is Tom Reynolds, president of the Reynolds Group, and I will be your host for the next 45 minutes. Welcome. Next Gen is a peer network founded 20 years ago, and it supports manufacturing, distribution, and technology companies. Our mission is to help business leaders adjust, leverage, and thrive. My background is manufacturing and software development. I use this experience to solve marketing problems and create better sales opportunities for my clients, not just leads. My business partner is Hema Day. She manages our SEO to sales department, a highly focused, financially driven, white glove digital marketing service. Like I said, helping me today is my friend Linda Feinholz. She's a business growth strategist and will be watching chat and helping me answer questions if people have questions and they're inserted there. I also have my good friend Kenneth Dunn, who's going to help me with communications, and she's a great writer and helps solve problems by getting pen to paper. Our speaker today is my really good friend and fairly new mother, although probably it's a year old now or something, isn't it? It's getting, yeah, right. Who is the managing partner of Hackler, Finn and Associates. She's also the founder. She's on my speed dial for all matters involving labor law. If any of my clients call me, she's the first person I refer them to. Her topic today is I wouldn't do that. There's been a marked increase in litigation against businesses concerning labor practices. Cindy's going to help us identify what to watch out for. Please mute yourself. I would appreciate that. And tell your friends that this is being videoed and they can see it on my blog, which is at www.reynoldsgroupweb.com. With that, Cindy, I'm going to let you do your own introduction and jump into the topic. Thank you so much for joining us.
Thank you, Tom. Thanks so much for having me. This year has been a crazy year. I hear the word unprecedented about every day, every other day. And, you know, January 3rd, my husband and I, it was a Friday night, we were sitting on our couch in our living room and we heard these like popping sounds and it was like pop, 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 pop. And my husband, being the looky-loo that he is, races to the front door to see what's going on outside. I swear to you guys, I thought they were gunshots. Like, we live in Pasadena and we're on the good side, but like, I swear, I was like, why are you running to the front door? There are gunshots going on outside. There are cops. And, you know, he like opens the front door, goes outside, and it turns out the house across the street from us and one over is completely on fire. Like, it is so on fire where I thought that sparks were going to come over to our house across the street. The neighbors next to that house were out in the middle of the street, like yelling, and the cops would not let them back in their house. I'd never seen anything like it. To literally stand outside our house for an hour and watch our neighbor's house burn to the ground was crazy. And that's really what it makes me think of when I think about employment law and my clients, because you can do everything you can to try and stay protected, right? Like, you can hire Jeff and he can help you with EPLI, right? Employment Practices Liability Insurance. You can hire Linda to make sure your business is still going to be there on day 91. You can have Barry help you with all the HR aspects of it. But sometimes a fire does happen and it just breaks out, and you need to do everything you can beforehand to be prepared. And then you need to be able to know what to do if shit does hit the fan, because this has been the craziest year of all time, 2020. And, you know, I've been preaching this for years now. I just want all of my clients and friends to be as protected as possible. And so with that being said, I've prepared a wonderful PowerPoint for you all, and I will share my screen if that's okay. And Tom, of course, being the marketing guy that he is, he helped me come up with the title, I Wouldn't Do That. And so I'm going to try and make this interactive because I know you don't want to just hear me talk your ear off for the next half hour, 45 minutes. But if you can open up your chat, we have a chat, right? Let me just open up my chat. I want everyone to put in the chat a number 1, a number 2, or a number 3. So we're going to take a poll right now. And I want to know what situation caused you to be on this call. Put a number 1 in the chat if you fired a bad employee and it's backfired on you. Put a 2 in the chat if you attend every single Next Gen meeting and you love Tom Reynolds because you're a Rockstar member. Or 3, if you've heard of other business owners who have come against really difficult employment issues and you just want to be as buttoned up as possible in your business or for your clients. We got a couple of 1s, 2s, and 3s. Well, I'm glad to hear nobody's is really backfired. Maybe just one of you. But yeah, I just think it's so important we do everything we can, to stay protected. So, for today, we're going to cover how to identify some red flags in discipline and termination policies. By the way, can you just nod your head that you can see my screen? I did our presentation last week. Halfway through, somebody's like, "Oh, we can't see your screen." I'm like, "Oh no, my beautiful slides." So we're going to go over, layoffs and furloughs, what those look like in the age of COVID, new pitfalls employers face today, best practices to avoid in lawsuits, and then also as a parting gift, I have a termination checklist for all of you. And Tom, I know you sent me a list of attendees today. Does that include everyone's email address? Yes? No? Yes. Okay, perfect. Because I will automatically then send everyone a termination checklist, which I think will help as you're, deciding who to fire, when to fire, and how to stay protected. So
and we've had a few latecomers, so wait for the final, okay?
Oh, okay, perfect. Will do. So we all know the term at will, or at least I think we do, right? And in California, the relationship of an employer and an employee is generally at will. This means that without an employment contract, the employer or the employee can terminate the relationship at any time, right? With or without cause. Over the years, however, California courts and the legislature have created exceptions to California's at-will presumption. And by doing this, they've increased lawsuits for wrongful termination. So it's just so important to carefully consider and document each termination. In fact, I was just talking through an employment agreement for a friend of mine. She's an employee at a hospital, and we don't represent employees, we just are on the employer side. But the agreement says that she has to give 90 days notice in order to terminate the agreement, right? That is just astronomical. If an employee wants to quit, you can't force them to stay with you another 3 months or another 90 days. I mean, that's involuntary servitude, which we don't have in this country. Once an employee knows that they're going to be terminated, they're going to likely start looking for another job, and it's going to be on your dime. So they become less productive at work and those types of things. So personally, I would never recommend a 3-month notice period, but that really negates the at-will relationship, right? If you're requiring someone to give that long of notice. And you know what? A friend of mine just said this recently to me. Sometimes you want to you really want to put as much care into firing someone as you do with hiring. Now, I'm an employment attorney. I am always, hire slow, fire fast. That's my motto. But when you think about some of your employees that have been with you a long time, and if it's time for them to move on, putting that care into it and letting them go, I mean, obviously as quickly and as easily as possible, but it helps reduce the number of employment lawsuits we see if you're able to do that, if you're in a situation. And we've represented all sorts of clients over the years. We've had clients get sued after an employee's worked for them for 25 years, just right here in Pasadena. We've had clients get sued. The shortest term one for a long time was 9 days. I just got one that's 7 days, where somebody worked there for 7 days and then sued the business. And then I've also had it where the best man at the business owner's wedding sued him for employment law claims. So, you know, there's so many business owners think like, oh, my employees, they're like family to me. They would never do that. And that's fine to think that way. You know, I hope that that never happens. But you always want to look at, as a litigator, what's the worst case scenario, you know, and how is this going to look in front of the judge and jury? And so that's really what it comes down to. So in employment having no specified term is, you know, the employment may be terminated at the will of either party on notice to the other, right? And employment for specified term means an employment for a period of greater than 1 month. This means that unless a contract specifies otherwise, employment is at will. And so I have a question for you guys. I want you to put 1 for yes or 2 for no. If you have an ad out on, let's say, Indeed, and you have the term in there, you know, I'm looking for a long-term employee. Do you think that, what do you think of that statement? Would you do that? 1 for yes, 2 for no into the chat. And yes, Tom is a rock star. Good. All right. Good. We have some sharp people on this call. You'd be surprised what we see. You guys are in the know, so that's good. But if you say that type of a statement in your employment ad, when you're looking for, let's say, a file clerk or even another attorney or, you know, an HR person, an insurance person, anything like that, that type of statement can be looked at poorly in 2 ways. 1, that you're looking for someone young, right? You want that person to stay with you for a long period of time. And 2, that it can be interpreted as a contract. And that could actually negate the at-will presumption that we have in California. So, you know, at-will employment protects employers against these breach of contract claims where an employee claims he or she may be fired only for cause, or that the employee was guaranteed a certain term of employment. And by saying, you know, we're looking for a long-term employee, that could easily negate it. So, all right, another question for you. 1 for yes, 2 for no. Who here has an employee handbook? All right, good. I'm so happy everyone has one. That is fantastic. All right, not everybody, but that's okay. Okay, who here has updated it in the last 2 years? 1 for yes, 2 for no. All right, so you really want to check in with your employment attorney. I would really suggest every year, but at least every other year. We represent a nonprofit here in Pasadena where they had not updated their employee handbook since 1972. You guys, it was like caked together. Nobody's looked at this in a long time. So, you know, let's just update those regularly. But my reason for bringing up an employee handbook is that you want to include that at-will statement throughout your employee handbook. And you want to repeat that at-will provision wherever there's any possibility that other subject matter can be read as creating a contractual or permanent employee relationship. And I know not everybody does employment agreements. You know, a lot of bigger companies tend to do them. And we had a cannabis company retain us at the end of March, right after the shutdown went into effect. And just 3 weeks prior to retaining us, they had their entire C-suite executive team sign new contracts that guaranteed them a position until 2021. And they had 6-figure bonuses to be paid within 30 days. You know, they didn't come to us prior to drafting these and having their entire C-suite sign them. And so they got hit very, very hard with COVID and the shutdown, and they ended up laying off 150 employees, like that. And the agreements that the C-suite signed said that the only way you can terminate this employment agreement is if it's for for cause, and for cause was defined as fraud against the company. So this company was on the hook for millions of dollars, and it's not a good move. I know a lot of us run smaller businesses, and we wouldn't think that we would put anything like that in place, but even those smaller businesses, it's important to say, at will, and if you have employment agreements, make sure you have them reviewed by someone, just saying. So at will employment, you can negate this at will relationship and create promises when you say, we're only going to terminate you for just cause. And essentially, this means that you should make decisions on a fair basis, treat employees who are similarly situated in the same manner. And similarly situated means employees who are in the same general job categories and have similar seniority and rank. So 2 employees who are both secretaries but in different departments are probably similarly situated unless one is a new hire and the other has worked for the company for years. So some common pitfalls we see for employers is not adding that at-will language. They unintentionally create oral contracts. We have a case right now where my client sold his business last year for $5 million, which is a good amount of money, probably not life-changing, but like a good amount of money. And he had one of his managers sit down with one of his employees and say to her, oh, you just need to stick it out. I think the company's going to sell. And if you just stick it out, you're going to get something with it. You're going to get shares and a bonus and all of these great things. Well, the owner had no idea his manager was saying this to, this particular employee. And now we've been in this lawsuit with them for a year, and we are saying, like, you're not going to get anything. You have no shareholder agreement. You have no shares that were assigned to you. The owner owned 100% of it, and it's still a thorn in his side a year later because I don't know what plaintiff's counsel is smoking. They're not getting anything. But my point here is that unintentional oral contracts can be created not just by you, the owner, but anyone of seniority or in a supervisory position. So keep that in mind. Having employees execute an at-will agreement that specifically states, we're just in at-will employment, you have no ownership rights or anything like that, certainly would have helped in this particular case. Okay, so discipline and termination policies, carefully crafted policies really help protect you. A stated policy of progressive discipline tends to erode into that at-will relationship. Courts have held that a promise of progressive discipline guarantees the employee ample warnings before termination. However, the practice of progressive discipline can support the employer. So if an employer follows this progressive disciplinary path, most employees will know why they're being let go, right? If they receive oral warnings followed by written warnings and possibly even a suspension, then there's ample evidence and you have a well-documented file, which in the event that decision of termination is ever challenged, you can go to the judge, you can go to the jury and say, look, they came in late every day. They had this, issue, that issue, so forth. So having a policy is great. If you do have a progressive discipline policy, though, make sure you say that you can still fire for any reason, with or without cause, because that will help you bypass this progressive disciplinary path if you need to. Because if you catch an employee stealing from you, to give them a written warning and then or an oral warning and then a written warning and then put them on suspension, I mean, that seems a little much. So just keep that in mind. What else was I going to say on this? I felt like I had another story for you guys here, but I'll continue to move on. Strategies to avoid modifying this at-will nature of employment in contracts. Clearly state that employment is at will, that the employment relationship can be terminated at any time with or without cause, even if employment is stated for a specific period. And that's what happened with the cannabis company. They had everybody on until December 31st of 2021. So want to be able to bypass that. Do not put explicit limitations on when and what circumstances an employee can be terminated, because you will be held to that later on. And then also include a merger and integration clause, which states that the written document constitutes the entire agreement between the parties, and that the parties cannot rely upon any representations or promises other than those specified in the agreement. And if my client would have had something like that, it would have been so much easier to get plaintiff's counsel to just go away. Okay, so discipline and termination decisions. Bottom line is you want to be consistent, objective, and logical. We had a case a number of years ago where it was a massage company. It was a day spa, and we had a massage therapist who had some wage claims against the spa. And this was before we got involved. You know, they were legit wage claims. He was not being paid correctly. He was misclassified, all of the typical types of things. But he was also showing porn in the break room to other employees on break, right? So not on company time, but just on break. And they never documented this whatsoever. This went on for a number of weeks, and finally the owner, you know, she's a small woman, she says, you know, you're out, you're fired, right? And we were in mediation over this, and the mediator, of course, asks to see the employee file, right? And our position, because we had no documentation whatsoever, is that, oh, well, we have a list of 7 people who can come in and testify to this, right? They can come in and say the type of porn it was. They can come and say, you know, what he was doing in the break room that was totally inappropriate. And, but were they there? Were they in the mediation? No. Had anyone bothered to write anything at the time it happened about what was going on in the break room? No. His employee file was perfect, and then they fired him. So, I mean, we took the position, of course, that he's a terrible employee, and we always take that position, but it makes our job so much harder when you don't have that stack of evidence. And people always say, you know, well, I have witnesses who can come in and testify, and that's all fine and dandy. But had we been able to respond to the lawsuit or to the demand letter initially with, look at his file, he's a piece of shit, you know, like, then the person can easily see, the plaintiff's counsel could easily see, you know, oh, I will not take this case, he has major issues, or, hey, there are some underlying real wage and hour claims, so let's just settle for $5,000 and be done with it. You know, it would have been a lot easier. So I bring up the Earl versus Nielsen media research case because this is a Ninth Circuit Court of Appeals case that shows really the pitfalls of inconsistent discipline. So in this case, an employee, the court basically concluded that an employee could proceed with an age discrimination case after she showed that her employer applied a formal disciplinary process to the younger employees, but did not apply the same disciplinary process consistently to older employees. Had the employer simply, you know, applied the disciplinary process consistently, they may have been able to successfully defend this age discrimination case early on. You know, it just shows the difference. And speaking of age discrimination, and because we're in COVID, I do want to share with you, we have a manufacturing client, and guys, like, we represent the best-hearted business owners. You know, my husband runs a business, my dad runs a business, my brother runs a business. They're all really good people. They're not trying to screw their employees out, and that's what I find the majority of my clients in. You know, they're all really good people who just have no idea or concept. So when the shutdown happened in March, my client, not my client at the time, but my client today, he said he was really worried about all of the employees who were over the age of 60, you know, because we didn't know much about COVID. It was hitting the elderly population a lot harder. And so he decided, I'm going to send home everyone over the age of 60. I'm worried about their health. And even though he had good intentions, he's literally asking for an age discrimination lawsuit. So I know sometimes we act very quickly as business owners. That's probably why we're in business, right? Like we're quick starters, we get stuff done. But, sometimes you need to take a step back when it comes to employment related issues and just run it by somebody. So basically how to make well-reasoned decisions. This is pretty self-explanatory. Have those objective standards, right? Like at-will employment does not protect an employer from an employee who claims that he or she was unlawfully discriminated against, illegally harassed, or fired in retaliation for exercising a protected right. In order to protect against these types of claims, employers should base termination decisions on objective standards, right? And those objective standards can include performance, attendance, job duties, those types of things. And then although we're not required to do so, most employers use verbal and written warnings, suspensions, and other forms of disciplinary action before termination. If you have a policy providing this progressive discipline approach, be sure your policy also states that you basically have the right to ignore this progressive discipline and terminate immediately at your discretion. And then it's just really critical to document problems with employees as they occur to substantiate the reasons for a termination. If an employer makes employment decisions based on objective standards and documents the reasons for its decisions, you're in such a much better position to defend yourself later on in the event something comes up. And, guys, I can't even tell you how many times clients come to me and say, oh, I should have fired this person years ago. I was giving them the benefit of the doubt. They weren't that bad, all these types of things. And then they're surprised when they get an employment lawsuit in the mail, especially now in these times, with unemployment continuing to increase, we're just seeing a rise in employment lawsuits. Okay, question for you. 1 for yes, 2 for no. Who thinks you can fire somebody for wearing a blue dress? 1 for yes, 2 for no. So objectively, right, blue dress, that doesn't really have anything to do with the age of the person. But when you think about it, blue dress, that could be discrimination against women, right? Unless it's in the handbook. So we've seen policies written in employee handbooks that say we prohibit bare midriff. And you want to stay away from claims like that because you are generally discriminating against a certain sex, right? We have one guy right now who's being sued, and he got his employee handbook from the local chamber of commerce. It's just not worth downloading something and using somebody else's, right? Trying to save $1,000 or whatever it is. It really can help if you have someone look at it who knows what they're doing. So just discipline and termination decisions, ensure reasonable, fair, and predictive decisions by considering these things, right? Work rules or performance standards. Is your disciplinary action reasonable and based on normal capabilities of others working under similar circumstances or conditions? Is the employee working at the same expected level as other employees doing the same job? Did you clearly communicate the work rules or the expected performance levels to the employees? And just this week, somebody came to me in Provisors and they asked me for a quote because they're a business coach and they wanted to share with the people that they're coaching, why it might be a problem to have really high, pie in the sky, goals for their salespeople. And I thought about this and, okay, you can have this objective standard, right? Like you have to hit $1 million in sales to keep your job or whatever it is. But if that is unrealistic and you're following up with this person saying, hey, where are we? You want to be careful that you're not creating this hostile work environment, right? Like you're not wrongfully terminating someone for failing to complete these goals that you've set in place that are absolutely impossible to achieve. Can you say must be covered from shoulder to knee? So what I recommend in employee handbooks is to say business casual, or, you know, what, depending on the circumstance and the type of business it is, you want to say something that is positive. And so a statement like that must be covered from shoulder to knee, is probably okay, Linda. And then just circumstances, you know, does sufficient evidence exist where the employee violated the work rule or did not meet the performance standard? Did you document this evidence? Penalties, is the penalty reasonable and appropriate for the violation? This brings me to my my rant with California law on employment penalties that are associated from misclassification. This is kind of off topic, but I'm so behind. I'm on slide 14 of 44. This is never going to finish, but I know we have like 6 minutes to go, but I will interject. You know, it's like you're speeding down the freeway, right? Like you're going 80 and a 65, you know, yes, you're speeding. Yes, you totally deserve a ticket. Is it a $400 ticket? Yes, hands down. That punishment fits the crime. Is it worth a $40,000 ticket though? In my opinion, I don't think so. You know, a lot of these guys are just small businesses running their day-to-day lives and their businesses and trying to grow and focus on that aspect where they're not necessarily keep documenting every single break, every single lunch, those types of things, even though we recommend it and I try and shove it down people's throats on how to do it. You know, and that's what I feel like it is with California law. It's just, is it worth a $40,000 ticket? And that's what I think of that. You know what? I do have another case for you guys just on here too that it made me think of. We represented, one of my attorneys represented a school district whose supervisor, he was a supervisor and under him was a bus driver. And this bus driver had destroyed district property. She crashed her school bus. Was it documented at all? No. Was it in her review? No, not even a note. I'll come back to this. So the supervisor decided he was so the bus driver filed a claim for sexual harassment against the supervisor. And because the supervisor came around and tucked in her tag right here, just tucked it in, and she filed a claim for sexual harassment. After that, the supervisor was going to start being honest in her reviews. And this opened up a retaliation claim against her by now being honest moving forward, right? A retaliation claim does not require that underlying claim of sexual harassment to be successful. So if you retaliate by terminating someone, it's a problem, right? If you retaliate in some way, even though the sexual harassment claim that was brought was probably worth nothing, right? Just tucking in somebody's tag, you can still get into trouble for that. And just one quick thing on documentation. If you run into an employee, you know, in the office or have a chat with them by the break room or something like that, that, you know, you may want to document, but it was just a verbal warning, send an email to yourself. This, you know, a verbal warning doesn't have to be this, you want evidence of a verbal warning. I guess that's what I'm trying to say. You know, not every warning has to be this full form written report, but you do just, if you can send an email to yourself, the importance is a time and date stamp. That is going to be key in the event anything ever happens later on. Tom, I'm not going to be able to finish on this. I'm so sorry. I managed the time so poorly.
It's all good.
You know,
Give us, make sure, do me a favor, and since we're getting close, give us like 3 to 5 really important takeaways on I wouldn't do that.
Okay. So I want to fire somebody without documentation, and, you know, record the verbal warnings, conduct any disciplinary actions in private. in the case of furloughs and layoffs, if you are furloughing anyone and they don't have a paycheck for a full pay period, you need to give them all their paid time off that's been accrued and everything else, because the labor commissioner is looking at that as a termination. So don't do that. I won't go into the WARN Act. I also wouldn't, if you have an exempt employee making, let's say, $100,000 a year, and you cut them down to part-time of half of that, $50,000 a year, you're likely in violation of exempt. They've probably had to switch from exempt to non-exempt. In order for somebody to be exempt, they have to meet two things: one, a salary requirement, and two, their duties. And so it wouldn't hurt to look at that. Anti-discrimination statutes, there's everything under the sun, it seems like, military status, union activity, religion, race, pregnancy, childbirth. I would never fire a pregnant woman, just saying. We've had clients who are going to terminate somebody on Friday. They bring that person into the office, and then instead of being able to terminate them, they say, hey, I'm pregnant. Don't terminate. If this gets to a judge or jury where they say, I told my boss I was pregnant and 2 minutes later I was fired, that doesn't look good for you. That's going
to keep that in mind.
Voting is coming up. Everybody has the right to vote. I don't know what happened. Now I'm like equity.
You still there?
Yeah. Can you hear me?
Yeah.
Okay. So you cannot terminate someone for jury duty or, military service, anything like that. I won't even go into FFCRA stuff right now. And then these are all new things that people are facing today. And yeah. A big thing right now is employees claiming whistleblowers, where they are saying, like, my boss doesn't have the proper PPEs in place, or they're not following standard COVID procedures or anything like that. That is coming down the pipeline every single day. So you can't fire somebody for doing anything like that or making any sort of claim. Just use caution, basically. I have so much more for you guys, but I'll wrap up with that. Let's see, look at how much stuff
I don't mean to rush you, and if you have a few more things you want to put in there, everybody knows I try to keep it to 45 minutes, but I think you've got everybody's attention. So, but I do want to leave a little bit of time for questions too, Cindy, so if that's possible.
Yeah, of course. If anyone has any
Are there any questions?
I'm happy to answer.
This is Linda.
Email me too if anything comes up. Yeah, Linda.
I just want to say I've heard a number of your presentations, and this is outstanding and worth your turning it into 90 minutes exactly in the style you're delivering it. If you've got 44 slides, do them all and then cut it up into pieces. And I just think this was fantastic.
Thank you.
Thank you. I appreciate that.
Are there any? I agree thoroughly. So, any other questions? Anybody want to raise their hands? And all right. So I go ahead, Linda. My screen keeps freezing, so I can't tell who's here and who's not.
I'm looking, and I'm not seeing any signals from anybody, and I'm not seeing any questions in writing. So folks, if you want to unmute yourself and ask a question, now's the time.
I have to agree with Linda completely, Cindy. I think that I feel badly I cut you off because there's a lot of great information here and you present it very well. So, and I love to be critical. So, and I don't know if you can hear me. So,
Cindy, I think what's interesting to me, I'll just propose this while we wait to see if other people would like to unmute themselves and pose a question. One of the things that's fascinating to me is it's become so complex. I think employees only know sort of the big five, like if I'm a woman, if it's about age, if it's about pregnancy, or if you've never told me and you now inform me that my performance isn't satisfactory and you're firing me. They sort of only know these big categories, but there's all these shades that a business owner needs to care about and actually know themselves and do training with whoever their supervisory and managerial and leadership folks are.
That's just it. And, you know, even when you have employees interviewing new employees, they could easily bind the company to something that, you know, you as the owner never agreed to. I mean, one law firm I interviewed with and worked at for a little bit, they had 6 different lawyers interview me, you know, and like now I would be a little bit of cautious to do that, because who knows, you know, if one of them promised partnership in a year or something, or, you know, said something that, oh, are you going to have kids soon? You know, anything like that, you can easily be sued.
Cindy, do you offer an auditing program for clients that may not be your client, but they just want you to come in and kind of audit what they're doing? Is that something that you guys do?
Definitely. We audit. And then something else that I would love to gauge interest, because I haven't started it yet, is like a 1 hour or 30 minutes every week at the same time. Just ask your employment questions, you know, for free.
Yeah.
Just because I really just want to protect people, you know, like it's the Wild West out there. And
that's a very generous
so
offer, you know.
Tyler, go ahead and unmute yourself.
Hi, Cindy. I thought it was a wonderful presentation. I just want to say, I thought the part you talked about with COVID and the whistleblowers and that whole aspect is something that I wasn't even really thinking about. And I think that's a fantastic point and a timely point. And you know, and kind of goes to what you're saying about having a weekly or a bi-weekly, something like that. I think that's a fantastic, something you threw in at the end there. And I was like, oh my gosh, I hadn't even thought about that. I bet that's going to be a huge concern going forward. And wonderful presentation. Thank you. I picked up a lot from it.
Thanks. Appreciate that.
It raised a question for me, Cindy, thinking about that business owner who, quote, sent home everybody over age 60 or 65. If that or any other business owner wants to offer it to employees who are X age and older to choose
Nope.
to go home.
Nope.
I'm assuming the same issue, that it's discrimination.
Mm-hmm.
Either you send everybody home or.
Right. It needs to be everyone or no one, or some objective standard, right? Like, do you want it or not? It's up to the employee to choose.
Are we waiting for lawsuits from people who are over 60 or over 65 who didn't get offered the opportunity to work from home? Will they say you endangered my health because?
Well, so it depends. I mean, we've been advising clients all year to, if you have the opportunity to have people work from home, do so. Like I've gone head to head with a couple business owners because they're so old school. They want to just be in the office. They want everyone there. They want to look at everybody. But I'm really pushing back on that, because if you can have your employees stay safer at home, I mean, I want to protect people's health. Right. And so, yeah, I don't know if that answers your question, but I think we're seeing a huge rise in all sorts of lawsuits.
Any folks have?
It's like anyone who had like even like sorry, Linda, anyone who had even like a remote thought about it, but they were happy or just, you know, kind of trucking along and then got laid off or furloughed or, you know, let go for some reason. Now they're like, oh, a year ago, you know, I was unfairly treated, or 2 years ago, because you can go back in a lot of employment claims 3-4 years. So no one is safe. And I'll leave you with that.
All right, Jeff, you got a question?
Yeah, Cindy, I'd agree with everyone that this is a wonderful presentation. I've worked with Cindy on numerous times doing these things. And I think that there are a ton of landmines out there, and appreciate what you're bringing to the table. If you're able to do the entire presentation, can you let us know so that we can get our clients to attend? And would you mind sending that out, Tom, if you've got that information?
Yeah, I'll make sure she has the email list, but sure, absolutely. I'll support you, Cindy.
All right, thank you. Very well done.
Yeah.
Hi, this is Vinny. Thank you for all the information. As you noticed, I didn't participate. And I have to admit out loud to the world, I'm new at Zoom and I didn't know how to handle a lot of things, but awesome presentation.
Well, we're glad you joined us, and come again, and you can practice your Zoom with us.
I definitely will. Thanks again. Awesome information.
All righty. So I'm going to sign off.
All right.
Cindy, you're awesome. Team, you're awesome. Thank you very much for coming. Everybody have a fabulous weekend. And I like nice people, which is everybody here. So
Thanks
all
a
right.
lot, Tom. Take care, everyone.
Care.